Hey guys, today we're looking at 20 questions on contract legal status. I hope you do well on your real estate exam. If you want more information, more questions, check out our channel. Also subscribe, hit the notification button. It's free to do so, and that way you don't miss a video. And if you have any questions, ask them in the comments. So here we go. Which of the following is not a requirement for a contract to be legally binding? A, offer and acceptance. B, consideration. C, signed by both parties. D, legal purpose. C, signed by both parties. While signatures can provide evidence of agreement, they are not always necessary for a contract to be legally binding. Contracts can be verbal or implied depending on the circumstances. What does consideration mean in the context of contract law? A, the exchange of something of value. B, the clarity of the contract terms. C, the time frame for performance. D, the legal capacity of the parties involved. A, the exchange of something of value. Consideration refers to something of value exchanged between parties to a contract, such as money, goods, or services. Which of the following contracts is generally unenforceable? A, lease agreement. B, employment contract. C, contract involving illegal activities. D, purchase agreement for real estate. C, contract involving illegal activities. Contracts involving illegal activities such as drug trafficking or gambling are considered void and unenforceable in a court of law. When can a contract be rescinded? A, when one party wants to change the terms. B, when both parties mutually agree to cancel it. C, when a better offer is presented. D, when the contract is not properly notarized. B, when both parties mutually agree to cancel it. Rescission occurs when both parties agree to cancel the contract and return to their pre-contractual positions. Which of the following is not a valid defense against enforcement of a contract? A, fraud. B, duress. C, mistake. D, non-binding arbitration. D, non-binding arbitration. Non-binding arbitration is a method of dispute resolution and is not a defense against the enforcement of a contract. What is the statute of frauds? A, a law requiring certain contracts to be in writing to be enforceable. B, a regulation governing real estate advertising. C, a guideline for conducting property inspections. D, a requirement for parties to sign contracts in the presence of a notary public. A law requiring certain contracts to be in writing to be enforceable. The statute of frauds requires certain types of contracts, including real estate contracts, to be in writing to be enforceable. Which of the following elements is not necessary for a contract to be considered valid? A, offer and acceptance. B, consideration. C, capacity. D, witness signatures. D, witness signatures. Witness signatures are not always necessary for a contract to be considered valid, although they may be required for certain types of contracts or in specific jurisdictions. What is the legal term for a contract in which one party is unfairly pressured into signing? A, unilateral contract. B, voidable contract. C, executed contract. D, bilateral contract. Voidable contract. A voidable contract is one that can be legally voided or canceled by one party due to unfair pressure or undue influence. Before we move on to the other questions, please check out our channel. There's plenty of questions there to help you pass your real estate exam. Also, hit the subscribe button and notification, and that way you don't miss a video. And also give us a thumbs up. It really helps us in the algorithm. It helps more people pass the real estate exam. Here we go. Which of the following contracts must be in writing to be enforceable? A, lease agreement for less than 1 year. B, lease agreement for more than 1 year. C, verbal agreement to sell personal property. D, verbal agreement to perform landscaping services. B, lease agreement for more than 1 year. The statute of frauds generally requires contracts for the lease of real property for more than 1 year to be in writing to be enforceable. What is the legal term for a contract that has been fully performed by both parties? A, executed contract. B, void contract. C, bilateral contract. D, unilateral contract. A, executed contract. An executed contract is one in which both parties have fulfilled their obligations under the contract. In contract law, what does the term meeting of the minds refer to? A, a physical meeting between the parties to the contract. B, the mental capacity of the parties involved. C, mutual agreement and understanding of the contract terms. D, a gathering to discuss potential contract disputes. C, mutual agreement and understanding of the contract terms. Meeting of the minds refers to the mutual agreement and understanding of the terms of the contract by both parties. Which of the following contracts is typically required to be in writing under the statute of frauds? A, month-to-month residential lease agreement. B, employment contract. C, purchase agreement for personal property. D, sale of real estate. D. Sale of real estate. The sale of real estate is typically required to be in writing under the statute of frauds to be enforceable. What does the term capacity refer to in contract law? A. The physical space required for contract execution. B. The legal ability of parties to enter a contract. C. The financial resources available to fulfill contract obligations. D. The duration of time for which the contract is valid. B. The legal ability of parties to enter into a contract. Capacity refers to the legal ability of parties to enter into a contract, including factors such as age, mental competence, and legal status. Which of the following is not a valid consideration in a contract? A. Money. B. Goods. C. Future promise to perform. D. Moral obligation. D. Moral obligation. Moral obligation alone is generally not considered valid consideration for a contract. And before we move on with the last few questions, go ahead and hit that like button. Give us a thumbs up if you like this type of content. It really helps us in the algorithm. Thanks. What is the legal term for a contract that is enforceable but lacks some legal formalities? A. Unenforceable contract. B. Voidable contract. C. Valid contract. D. Executed contract. A. Unenforceable contract. An unenforceable contract is one that is valid but lacks some legal formalities, making it difficult to enforce in court. Which of the following is not a requirement for a contract to be valid? A. Offer and acceptance. B. Legal purpose. C. Written agreement. D. Consideration. C. Written agreement. While some contracts must be in writing to be enforceable, not all contracts require a written agreement to be valid. What type of contract involves a promise in exchange for an act? A. Unilateral contract. B. Bilateral contract. C. Executed contract. D. Voidable contract. A. Unilateral contract. In a unilateral contract, one party makes a promise in exchange for the other party's performance of an act. Which of the following is a valid defense against the enforcement of a contract? A. Substantial performance. B. Novation. C. Ratification. D. Estoppel. D. Estoppel. Estoppel is a legal doctrine that prevents a party from asserting a right or defense that is inconsistent with the previous actions or statements. What is the legal term for a contract that is valid and enforceable on its face? A. Void contract. B, executed contract, C, valid contract, D, unenforceable contract. C, valid contract. A valid contract is one that meets all the necessary legal requirements and is enforceable in a court of law. Well, thanks for viewing our video. I hope you enjoyed it. I hope you learned something. Also, check out our channel. We have many questions that'll help you pass your real estate exam. Please subscribe, hit the notification button. It's free to do so. That way you don't miss a video. And also hit that likes up button. It helps us in the algorithm. If you have any questions, ask them in the comments. Have a great day.